This is ramondeleon with SmoothOperationofLaw, and I got another video for you. I haven't posted any videos for a while because I was letting the comments on the YouTube channel grow, and I've been dealing with a bunch of trustees that are part of SmoothOperationofLaw's trust. So, long story short, tonight I got some proof for you, okay? This is coming from the American Bar Association Intellectual Property Law section, okay? You can see it on the top left. This communication was sent to the Honorable Andre Iancu, however you say that, on December 21st of 2020. December 21st, 2020. That means a little more than half a year ago. And Andre Iancu, or whatever their name is under the Secretary of Commerce for Intellectual Property and happens to be the Director of the United States Patent and Trademark Office. So here's the deal. Let me paraphrase this along with read a lot of the material that's inside of the letter. But before I do that, let me give you a preface. This communication is regarding the United States Patent and Trademark Office, and it is a request for information of state sovereign immunity due to the impact on trademark infringement. I'm going to tell you right now, these guys got questions of what SmoothOperationofLaw already knows. There just came out a Supreme Court case a few months ago that publicized the effect of SmoothOperationofLaw's methods, which means that if you want to know if SmoothOperationofLaw has validity to a lot of their claims regarding trademark infringement and protecting yourself, the fact of the matter is you now do. And this is their communication. So here it goes. Dear Undersecretary whoever, Iancu, the American Bar Association section of Intellectual Property Law, the section thanks to the United States Patent and Trademark Office for the opportunity to provide comments in response to the USPTO study on state sovereign immunity. The views expressed herein are presented on behalf of the section and have not been approved by the House of Delegates or the Board of Governors of the American Bar Association. Accordingly, they should not be construed as representing the position of the ABA. The section is pleased that the USPTO has taken action to confront this important issue in intellectual property law and provides herein some preliminary comments regarding the impact of state sovereign immunity on trademark infringement claims. State sovereign immunity impacts the ability of trademark owners to protect against and rectify infringement and dilution of their trademarks by state government actors. When states commit infringement and parties cannot stop that infringement or seek adequate compensation, trademark owners are effectively deprived of their full property rights and consumers are likely to be confused in the marketplace. Now, listen to what I'm about to say right here. As confirmed just this year by the Supreme Court in Allen v. Cooper, which is 2020, Congress has the power to abrogate sovereign immunity only when there is, 1, more than innocent or negligent property deprivation, and instead a pattern of intentional or at least reckless deprivation, and 2, no adequate state remedy is available. Let me explain that. Congress has the power to abrogate sovereign immunity only when there is 1, more than innocent or negligent property deprivation, and instead a pattern of intentional or at least reckless deprivation. So in order to prove point 1, you have to send a cease and desist. That way you communicate to them that it is your trademark, and then after that, if they continue using your name as a mark for whatever financial gain they got, that could be on court papers and you got a prosecutor that's getting paid to dilute and confuse the public on your name. When that happens, after you send that cease and desist, what you just proved is willful infringement. So you'll meet criteria 1. Criteria 2, it says, and 2, no adequate state remedy is available. Now, I'm not going to get into that because that in itself is part of the trade secret. If you want that, hit me up on Messenger. But this right here is proof of a communication dealing with state sovereign immunity and the fact that Alan V. Cooper has pretty much clarified what the criteria is for a state to be held liable in federal district court over violating your trademark and continue to use it. They don't just get to walk away with your intellectual property and use it after you send that cease and desist. Now, if you have any questions, you can look up Alan V. Cooper. I'm trying to highlight it, but it's not, well, you know what? I'm not going to do that because I don't want to mess up my video. Here's the deal. You can highlight Alan V. Cooper. It just came out June of last year. So when people are asking, how powerful is trademark? You have the Chicago, well, this, at least the ABA of Intellectual Property, the law section that communicated this letter to the United States Patent and Trademark Office is based out of Chicago. Look at the top right corner. It's on 321 North Clark Street. So with that being said, they're asking questions because Alan V. Cooper just made the very same process that I speak of public. And now you can get a public remedy without having to draw all of these freaking case laws tied with an arbitration proceeding and so on and so forth. You don't have to do a lot of the work that I used to do, which I still show my Smooth Operational Law trustees. The reason why I show it is because you guarantee big amounts. And it doesn't have to be public, and it can be subtle and be expeditious. You try to go into public and you do a claim under Title 15, it could take you up to 7 years with motions to continue. But if you do it the Smooth Operational Law way, maybe maximum with all the proceedings, 120 days. So when you're using trademark and you're trying to get a state actor to stop using your name as a trademark, now you know. Even lawyers don't know. That's why the intellectual property law section has to clarify, because the judicial precedents just came out that verified what Smooth Operational Law talks about. You can check my other videos. If you got any questions, like, share, subscribe, and hit me up in the comments of the YouTube video, and or look inside of the description and communicate with me on Facebook or Messenger. Messenger is best. If you call me up on Messenger and you send me a friend request or whatnot, I'm going to pick it up. You can hit me up there or on my Facebook page. And I'm going to tell you right now, it'll probably be the best thing since pockets on pants. So, one last thing. I haven't been really looking inside of a lot of the, the communication sections of my pages. But I'm going to tell you right now, I saw some people saying, hey, man, you sound like an agent. Let me clarify that. I do. Let me tell you why. Not that I am. The reason why I sound like one is because I do it off of a Google search. Look, it's on Google. Anything that's in law doesn't have to be private. Why? Because it's for public access. It's reasonable expectancy of due process. Okay? So these tools are all over the place. So that's why it sounds like that. And I'm happy that I sound that qualified. It's kind of like a backhanded compliment. I'm laughing at you. So if you got any questions, go ahead and hit me up on Facebook Messenger again. And I hope you guys have an outstanding day. And come and find out how you can learn about showing that there's no adequate state remedy. The way that I set up my process is so cool, so smooth. But you can only get that if you hit me up. You need both prongs to pierce the veil. The lawyers are shaking. Maybe people got something to do with it, right? But they're asking questions. You see it on this letter. So it works. The process works. Have a good evening or day or whatever time it is for you.